Number 123, People versus Barksdale. Counsel, you want any rebuttal time?
2 minutes, please, Your Honor.
2 minutes. Go ahead. You're on.
Good afternoon, Your Honors. Jan Hoth for Appellant Anthony Barksdale. Appellant's mere presence in the lobby of the TAP building did not justify the police actions here.
Let's talk about what a TAP building means and how that interfaces with the idea of presence. What does it mean when you're a TAP building?
According to the police precincts, a building's landlord owner can enroll a building in TAP merely by signing an affidavit that the building
And
is...
once you enroll it in TAP, what does it mean?
It means that it gives the police permission to enter and patrol where they otherwise would not be permitted to do. But it in no way diminishes a person's right to be free from unreasonable search and seizures. If we're talking about...
So all in practical terms, it says, gee, keep an eye on our building because we have problems?
Yes. Well, in practical terms, that's what, at the time the affidavit is being signed, the landlord is affirming. But in practicality, there's no systematic guidelines or procedures that even ensure that that is, in fact, the truth. Landlords can enroll buildings in TAP when their buildings are not suffering from crime at all.
So in your view, it doesn't mean that much? Is that what you're saying, that you're a TAP building?
What it means is that
the landlord unilaterally says, gee, come in and
what it's done is give the police the authority to patrol buildings the same way they have the authority to patrol NYS buildings, which are public, and they are the people who patrol it. So here we have private buildings, and the landlord is saying, I want the police to come in and patrol.
How does that affect the tenants?
Well, it's very significant that it's the landlord who is making this decision, and he apparently can make it unilaterally. There's nothing in any record submitted anywhere, particularly not in this case, that would suggest that the tenants are even asked whether this is something they're interested in.
So the landlord is authorizing police to go to any part of the building that the landlord could go to, in terms of the common areas?
I believe so. Typically speaking, what the police do under this authorization is conduct vertical patrols.
So then what the landlord has done is basically made those private common areas a functional equivalent of the street that's open to the public, in the sense of what the cops can do, which is they can enter and look around and walk around freely.
Exactly, Your Honor. In respect to police actions, I wouldn't say they've made it the equivalent of the street.
No, that anyone can walk in, but for purposes of what the police can do.
Exactly, Your Honor, because it's not even clear on this record how the police entered this building. They're supposed to be under TAP, given keys so that they can enter, but here the officer involved had no idea how he entered the building.
So if the bore level 1 is the minimal basis by which a police officer can make an inquiry, it's not probable cause, it's not some higher threshold, why isn't the TAP understanding or agreement, certification, whatever you want to call it, enough?
Well, there's two reasons. One, although the court below treated this as a level 1 inquiry, and most courts historically have been treating it as a level 1, put in context, it may amount to a level 2, but it's certainly more intrusive than a level 1.
But you didn't argue that. That wasn't argued in either of the courts below.
Counsel argued that the police did not have a constitutional basis to stop, inquire, and question. Nobody anywhere argued level 1, level 2. The court below said this was a level 1.
What if you have a TAP building, like in your building, and then you have the no trespassing sign, and you're beyond the no trespassing sign? In combination, is that enough?
It's not, Your Honor, because there's nothing inherently suspicious about simply standing in the common area of a building, even if
How else, though, do you determine a trespass? You've referred to it as mere presence, but a trespass is presence. That's what it is. You're in a space that you shouldn't be in. It's nothing but presence. So the logic of that is, how else can you determine that except to say, do you live here? How else would you make that determination? Well, besides some sort of basic inventory question.
Well, I would first say that a police officer in uniform approaching somebody in the lobby of a building is not unobtrusive. They're approaching because...
That I don't, honestly, it's irrelevant. At this point, if it's unobtrusive, my question is whether or not it's a proper question. And I just can't figure out how else you would determine a trespass is taking place unless you ask someone, do you live here?
Your Honor, first of all, what that means is that the police would then be authorized to ask everyone they encounter.
I understand.
Go ahead, Judge. I'm sorry.
I was just going to piggyback on that. Let's assume for a minute, not your defendant, but a defendant is an upset husband or boyfriend of someone in the building, and he's going there with a specific purpose of doing something bad. The police see somebody in the building, and they want to know who he is. What should they do?
Well, what are they witnessing? Are they witnessing him simply standing there, or are they witnessing presence plus something? Something that would give them an objective, credible reason to approach.
There is no plus in the trespass charge. The mere presence is the trespass. So there doesn't need to be something else. If you're in a place that you're not supposed to be in legally, that's the trespass.
But it's your argument that someone who lawfully have the right to be present will be conducting themselves in the exact same way.
Exactly.
You can't base it on mere presence.
Exactly, Your Honor.
So what is it then? There has to be a particularized reason to go over to the.
Your Honor, there has to be an objective, credible reason.
Yeah, how do you get there?
Well, they could have simply.
Give us some examples of where, let's say, for the sake of argument, that you're right that you can't tell one person from the other, and it's a tap building, but does that apply to every person who's present? So what beyond that do you have to have? Mere presence, we understand is your argument. What particular things would warrant it?
An example in the past is that when, upon seeing the police, they act very suspiciously. I don't know what that would entail, or somebody seen in the lobby and they stand there for 15 minutes, they don't talk to anybody, they don't move. The officers here approached immediately. They could have stopped and watched for a bit. An invited guest would be called upstairs.
If they had stopped and watched for a bit, would then that be okay?
If Mr. Barksdale had continued to stand there and do absolutely nothing, 5 minutes may be not enough, but after 15, why is he still standing in the lobby? That might be enough.
So what if this building was unstaffed, obviously, right? But if someone came into the building, or there had been some new employee who didn't know the residents of the building, and somebody came in the building and asked, and the new employee asked, why are you here? Would that be something bad that you couldn't do?
Well, I
think
think
if this were a staff building, are you saying that you couldn't ask somebody that an employee didn't recognize, even if it were a resident, but the employees knew doesn't recognize that person? Are you saying that question couldn't be asked, who are you and what are you doing here?
I think the difference there, Your Honor, is that the residents in staffed buildings have opted to live in a staffed building. And there is a big difference between being approached by a doorman, new or old.
They can afford to live in a staffed building, but some people can't. And so if they can't, then they're not entitled to find out who's in their building?
But there are locked doors and buzzers. These buildings are not completely without security. So the question is being approached by a doorman that you've opted to live in the building and opted to have someone monitor who's coming and going, is that approach different than being approached by a policeman in full uniform who
So let's say the landlord takes a vote, sends everybody a letter. Do you want to be part of TAP? And everybody signs on. Now can the police just stop and ask anybody? Because now the tenants have agreed that not only the door person, but someone else or an employee can come and ask?
I would argue
Any in the lobby?
I would argue that even though DeBoer would say that it's not permissible, if the tenants are voting, that they don't mind having their everyday lives disrupted, but because they're
But
really
how does that affect the rights of this person who is not a tenant? How can the tenants voting to have the police be there make any difference? Aren't the rights of this non-tenant the same whether the tenants vote one way or another? I don't understand that.
Well, I'm saying, Your Honor, that under De Boer, no matter how many tenants voted in favor, it would protect anybody standing in the lobby because they don't have the right if all you're doing is standing there. What I'm saying is that if the tenants are voting, then there's less of a public policy problem, but it still violates De Boer.
I guess the thing I'm still struggling with is, how is this not a trespass? Now, I understand your argument about your De Boer argument. I'm not sure I agree with it, but I understand what you're saying there. Did the police have a legitimate basis, an objectively credible reason to approach them in the first place? But you're in a building, it's a privately owned building, you don't belong there, you're not visiting anybody there. How is this not a trespass?
But, Your Honor,
that question, objectively, isn't this a trespass? Am I missing something?
well, you're looking at the end result. We have to look
No,
at
I'm
the
just looking at the
police's
person standing in a privately owned building, a private building. A trespass is just mere presence, as you say. I accept that, but I would just call it presence in a space where you're not entitled to be. How is that not a trespass? And the second question, of course, is how do you determine if that's a trespass, except by asking the person?
And I say that what the police have to do, if they enter a building and they see somebody standing there, they can monitor the behavior.
So the rule
But
that
what
you're
about
asking us to make is that it's okay if the person's standing there for 20 minutes or 15 minutes or 10 minutes? Where do we draw that line, if that's the rule?
My rule is that there has to be presence plus something.
Okay.
Thank you, Your Honor.
Counsel.
Good afternoon, Your Honors. May it please the Court. My name is Sheila Bautista, and I represent the people in this case.
Counsel, is your position that we can presume that everyone who's in a TAP building is a trespasser?
Absolutely not, Your Honor.
So if that's not the answer, where do you disagree with your adversary saying it has to be more than mere presence? That TAP building, fine, but the landlord can't give away everybody else's rights. So if you're there and you haven't done anything, she called it plus, there isn't anything more, you're just there. Can we presume that you're a trespasser and start asking, well, what are you doing here? You're visiting someone, what's going on? Answer that. I think that's the nub of really what we're dealing with here.
Your Honor, the question doesn't presume that a person is necessarily a trespasser. Level 1 questions can be asked absent any indication of criminality.
So you can do not, so mere presence in a TAP building is enough?
In this case, yes.
Why in this case?
In this case, because the defendant was just standing in the lobby where it was unlawful for him to be. These police officers, there's something key about TAP buildings.
So anyone, I come back to my question to you, anyone standing in the lobby who is present in the lobby, we can come and ask, what are you doing here?
Yes, because the police officers have been asked to address the crime that could be committed by being in the lobby, without authorization.
The police officer is asked by the landlord under this TAP.
Because
the tenants, remember we went through this helping your adversary, the tenants haven't voted for that. The landlord can't give away everybody's rights.
Your Honor.
So the designation of a TAP building means automatically you can come in because the landlord has asked. You can ask anyone there, presume that they might be trespassing, let's put it that way, and ask whatever questions you want. The Boer one, whatever. Why is that appropriate?
Your Honor, TAP building.
The usual test, I guess this is what I'm driving at. The usual test is some kind of conduct, some tip that would lead you to believe that there may be an issue here. Just get me around that. That's what I want to do.
Your Honor, TAP buildings started because drug dealers were taking their business from street corners into people's residential buildings. They were taking them into the lobbies. They were dealing drugs from the lobbies.
Do you agree with her statement that the landlord can just say, I want you patrolling my building?
Your Honor, this is the case where the officers were asked to
Yes or no? Do you agree with that?
Yes, the officers were asked by the landlord to.
I get. So, okay, that's a given. A TAP building, the landlord says, I want you in there.
Because
the landlord take away everyone else's rights.
The landlord is authorizing police to provide the security that these residents don't
But
have.
your response is the landlord cannot take away other people's rights. The question is whether or not that's happening here. Isn't that really correct?
Correct, Your Honor. There are situations where a person can be present in the lobby.
Okay, so counsel, let's get to your point that the mere designation of a building under TAP satisfies the Boer 1's objective, credible reason requirement.
Yes.
How does it satisfy that requirement? That struck me as a requirement about individual conduct.
Your Honor, there's
TAP is about a broad sweep in your building.
A TAP building indicates two things. It indicates that the building has suffered a history of crime by trespassers. That's how the program originated. It also
We've held that the fact that it's an area that is known for criminality isn't enough.
in McIntosh that was the case because the entire city of New York was a high crime area.
But isn't the point that you're looking at the individual, because it's the individual's constitutional rights we're talking about?
We're talking about the individual's constitutional
What has this individual done that provides the objective, credible reason for the officer to ask them anything?
His behavior is consistent with the crime that the officers have been asked to address.
The behavior of standing in a lobby is consistent with trespass?
This is a restricted area.
Well, can we back up on that?
Don't we get back to the Chief Judge's question? That means everybody is subject to questioning. There's not one person being excluded. Maybe the person who's got the key who's opening the door.
Exactly.
But otherwise, anyone else. I'm standing in the lobby waiting for my friend.
That's possible, but that's the nature of every level 1 encounter, because a level 1 encounter allows a question.
Only if you say standing in the lobby and doing nothing else is enough, which I think is the question we're asking.
In this case, yes, the person is just standing in the lobby. His behavior is consistent with the crime that the officers have been asked to address.
Judge Fahey.
Sorry, Judge Fahey.
That's all right. Let's back up a little bit, though. Judge Fahey raises the point that at some point you've got to be able to ask some questions. Now, in this particular case, not only is it a TAP building, but does TAP buildings require this? There was a no trespassing sign.
There was a sign in that lobby that said that. Yes.
That was a preamble to my question.
Yes, sorry.
And as I understand it, there's a foyer, then there's the locked door, and then there's where this particular person was questioned. So when the officer was asked, how he got in, he doesn't remember. He said, we went through the door. I don't recall if it was open or if we buzzed to get in, which I thought was rather significant because it's kind of important, it seems to me, on the trespass issue. And then he says, as I recall, I saw a sign. I can't recall if it was posted inside the lobby or in the front of the building or exactly where. He didn't know what the size was, what the color was, or anything about the sign itself. And it struck me that if he didn't, maybe the person who was just standing there waiting for his friend to come down didn't either. And therefore, he or she may not be guilty of trespass, even though, because it's a TAP building, this officer took it to mean that he could inquire and that, in fact, he may have been trespassing.
Your Honor, if you look at pages A12, A19, and A20 of the record, the police officer testified many times that there was a trespass affidavit sign in the lobby. It was posted in the lobby. He wasn't unequivocal about the fact that there was a sign in the lobby. He may not have remembered exactly what it looked like.
I'm looking at 20 line 1. It says, as I recall, I saw a sign. I can't recall if it was posted inside the lobby or in the front of the building or exactly where.
But he recalled that there was a sign in the lobby. And
at 17, he said, I don't know if the building was part of TAP until I spoke with the assistant district attorney.
Your Honor, he was
after the arrest.
Your Honor, he was on an impact post. He was on a particular patrol to address.
Does that give him unlimited discretion? How is this different than like the roadblock cases, where you can do everyone or you have unlimited discretion? That's the question. Does this sign that he's not even sure exactly where he saw it or what it is, we're not sure whether the door is open or not, does he have unlimited discretion? That's what troubles me. Anybody, anything, do we know here that gives him that right?
Your Honor, if the person used a key to get into the building, if they were using their key to get their mail.
He may be trespassing. Go ahead.
If the person was using their key to get their mail and his behavior is more consistent with a resident,
what if the
then it
resident is just waiting
might not
for
be
their
as reasonable.
friend?
Sorry?
What if the resident is just waiting for their friend?
If the resident is just waiting for their friend,
in the lobby,
then it's permissible for the police officer to ask the question.
Well, it sounds like your rule turns De Boer and the law on its head, right? Your rule is, if you conduct yourself in a way that appears that you're not committing a crime. You don't have to be asked, which is not our law. Is you have to have some kind of conduct or something that suggests to the officer.
Here, the objective credible reason, absent necessarily criminality, is that the police officer is trying to make sure that everyone's in the lobby, belongs in the lobby, is lawfully in the lobby, because this is a building that has suffered
What
crime
I'm
by
saying is
trespassers.
that your rule is that everybody fits that category unless they show otherwise, which turns our law on its head. Because there's no way to know that until you ask and perhaps they answer, which leads me to my next question. Let's say the officer goes up and asks, and he says, I don't have to talk to you. I'm not answering your question. Now what?
In that case, the officer can try to take reasonable steps to ensure that he lives in the building. The officer can explain, look.
I understand. Doing what? The person says, I don't want to talk to you, and I don't have to speak to you.
The officer can say.
Leave me alone, or starts walking away.
If the person refuses to answer the officer's question, that could reasonably raise the officer's level of suspicion, because this is a building that can be committed by mere presence in the building. And if the person doesn't
That goes back to the basic elements of trespass, which are, of course, you're in a place we aren't legally obliged to be. Now, I know your red light is on, but I got a hypothetical. I don't get to the city as often as I should, but I guess the Sherry Amsterdam is one of the biggest hotels there now, right, still? And over the summer, I grew a beard to the consternation of many of my colleagues. And if I was
Not true. Go ahead.
If I was standing in the lobby of the Sherry Amsterdam and the doorman came up to me and said, why are you here? Because he didn't like the way I looked. And I would say, I'm waiting for my sister, that would be a perfectly legitimate response, right? Now, if a police officer came and asked me that same question in a private building, why are you here? And I say, waiting for my sister, perfectly fine. I said, I'm just waiting for somebody. And he says, who? And I can't respond to him. I say, are you staying here? No, I can't respond to him. Is it any different if it's a Sherry Amsterdam than if it's a housing unit with 600,000 people in it, like in Queens somewhere?
Your Honor, you have a right to be in the Sherry Amsterdam. People don't have a right to be in a building with no trespassing signs, locks, buzzers,
so the
and
difference
history
is
of
the
crime.
affidavit, right?
That's what makes this different, is that.
And so then we get, of course, in the Sherry Amsterdam, everybody wouldn't have to agree to have some doorman come up and ask me that question. And now, you haven't really responded to the question of whether or not people are giving up some right by saying you can't illegally trespass in my building. Right? You need to respond to that.
Your Honor, it's the nature of a level 1 question. A level 1 question is allowed to be asked.
And that's because it's only the element of the crime of trespass is simply the presence in a place where it's not legal. You don't have a legal right to be there.
Correct, Your Honor.
But isn't that true of any crime which is currently being committed, but it's not obvious from its face? I'll give you an example, weapons possession. I've got a gun in my back pocket. You can't see it, but I'm obviously committing the crime, equivalent to the trespass that Judge Fahey is talking about.
But
what's the difference?
The officer may not be able to see any sign that there's a weapon. But in this case, being just present and just standing in the lobby of that building, that constitutes that crime.
One last question. Your rule really is, and I'm not saying judgmentally either way, once it's a TAP building, that's the end of the story. You can come in and question mere presence. It's the TAP building that's really your test. Right?
Just standing in this case. But if there were other residents who are apparently a resident, using keys, carrying groceries, et cetera, then maybe it may not be as risky.
Would your answer be the same if there was no sign posted? It was just a TAP building. Is that enough, or does there have to be a sign posted so that somebody coming in would know that they shouldn't be there?
Your Honor, the sign helps, but it's not the key here. There is the fact that the building is locked. There's a buzzer system, which indicates you're not allowed in this building unless you live here.
I'm sorry.
One last question. Judge Rivera.
So I just want to understand. If someone is approached by a police officer in the lobby and the person refuses to give them an answer, under your rule, how far can the officer go after that to try and determine whether or not, indeed, this individual is a trespasser?
Your Honor, if the person refuses to answer.
Absolutely refuses. I don't want to talk to you.
After the officers good faith efforts,
Yes,
then that could raise the officer's level of suspicion, because this is a crime that a person.
I understand, but then my question is, what would the officer then do? Would the officer then be authorized to frisk the individual, to arrest the individual? What is the next step?
The officer could try to explain,
Right, and the person again says, I don't want to talk to you.
Then perhaps the officer could ask the person to leave the building, because only people who are allowed to be in the building, according to the sign, are residents or their authorized guests.
And must the person leave the building upon direction by the officer?
Well,
It may be in their best interest to do so.
it may be in their best interest to do so.
Okay, counsel. Thank you. Rebuttal, counsel.
Your Honors, practically speaking, an encounter between the police and someone in the lobby of a TAP building ends in one of three ways. First, they produce valid identification to prove that they actually live in the building. Then they're allowed to go upon their way. Second, they name the person that they're visiting, and the police go and knock on the apartment door and say, has this person been visiting you? Are you expecting them? If they get corroboration from the person who answers the door, you're allowed to go on your way. If none of those things happen, you're arrested for trespass.
Are there requirements in a TAP building, once the affidavit is signed, to post trespassing signs?
It's part of the TAP program that signs are supposed to be posted, but the police operate in TAP buildings whether or not the signs are posted.
Right, but what I mean is, if it's a TAP building and they're supposed to put up the signs and they don't, I would think it's a different situation.
Right. We're not challenging here whether the sign was posted or not. We're assuming for the sake of argument that there was a sign, and we're merely saying that standing in the lobby alone.
Well, there's one thing in between there. If there's a sign that says no trespassing, and this person, for the sake of argument, is not supposed to be in the building, there's still the locked door. There's the foyer, and then the locked door that gets into the lobby.
Again, on this record, we don't know if the door was locked.
Right. That's why I was asking the question. I don't know if that's if all TAP buildings require that, so that if the cops see somebody who's gone through the locked door and is, what in their view is loitering, do they have the right to ask if he's in fact trespassing?
Well, going through a locked door would be the plus that I was suggesting before, and I think my rule would
Unless someone is just walking out the door and you go right in. It's not indicating that you would have otherwise independently been able to go in the door.
Right.
I think it's really what Judge Piggott is asking about.
I think that if the police observe you piggybacking into somebody through a locked door, that might be the plus.
There's some case law on that.
But it may not be.
What's your answer to my question to your adversary, the individual who refuses to respond to the police officer? What
They're
can
going
the
to get
police
arrested.
officer do after that?
They're going to get arrested for trespassing.
Whether they can. My question is, what, under your understanding of the board, is the officer authorized to do? Arrest them?
Under my understanding of DeBoer, the officer wasn't permitted to go and question the person unless there was something more than standing in the lobby. If I'm standing...
Let's say we ruled against you on that, but the person takes the position, I don't have to answer you. We've said in the past you don't have to speak to an officer. It doesn't answer the officer.
Correct. I believe then the officers can do, under my rule, the officers can do nothing but watch you. If you're a legitimate tenant, you're going to go to your apartment.
They could call the landlord. They could, they could call back for instructions. There's a number of options that they have. They don't have to just walk away, right?
No, I wasn't suggesting that they had to walk away. I was suggesting the most obvious. If you think the person doesn't belong there and you continue to watch them, a tenant will either go to their apartment or a visitor will buzz up and go to an apartment, or their friend will come down, or they'll simply leave the building. A trespasser isn't going to continue to stand there while the police are watching. I think the police watching would illuminate the situation.
As Judge Piggott suggests, the police do something else that's not intrusive to the individual in terms of physically or otherwise, but can try and confirm that you're authorized to be there.
Same thing.
And it may be the wiser course to leave if you're not authorized to leave.
Okay, counsel. Thank you both. Appreciate it.